Mrs. Vanderzee and her husband, Mr. Vanderzee, appeared in front of Judge Judy to make a claim against Mr. Berhane, the owner of a car wash and detail business. They claimed that the defendant was responsible for damaging a piece of artwork that was in the trunk of their car, which they brought in to be detailed. Mrs. Vanderzee drove the car in on October 31st, a Saturday, around 11 in the morning. Mr. Berhane took the key from Mrs. Van, but she did not remember seeing him. According to Mr. Berhane, he took the key from her around 10:30. Mr. Berhane described his establishment as a full-service car wash that has been operating for 60 years, with him being the owner since November 2009. They mainly offer full service, but also offer detailing services, with one car a day being brought in for detailing. The prices for the services offered vary, with different options available, such as different types of wax, tire cleaning, and undercarriage cleaning. When the Vanderzees brought their car in, one of Mr. Berhane's employees had a clipboard and was going over what services they wanted, checking off boxes. Mrs. Van stated that they wanted everything done except the trunk, and they specifically requested that the trunk not be touched. Judge Judy listened attentively to both sides and was impressed with the establishment. She asked Mrs. Vanderzee what services she specifically ordered, to which she replied that she wanted everything done except for the trunk. And she claimed that her artwork was damaged during the car wash, but Berhane argued that the artwork was already damaged when he received the car. Judge Judy asked about the details of the service and how much it cost. She learned that the cost was $90 plus tax, and the service took 2 to 4 hours. Mrs. Vanderzee produced a receipt for $106. The judge asked about the artwork, specifically when and how it was loaded into the car. Mr. Vanderzee stated that he loaded the artwork into the car the day before they took it to the framer. The couple had an appointment with the framer on Friday, but he wasn't there when they arrived. They took the artwork, which was rolled up, but not in a tube, with them. Mr. Van admitted that he now has a tube for bringing the artwork on airplanes. Judge Judy asked about the time of their appointment with the framer, which was 4 p.m., but the framer wasn't there. He stated that he is a professional artist, so Friday is a work day for him. He was driving the car when they went to the framer, and his wife was in the car with him. The judge asked several more questions, trying to determine the cause of the damage to the artwork. But the dialogue ends there. When they returned to pick up their car, the painting was missing. Judge Judy questioned Mrs. Vanderzee about the painting, asking if she had contacted the framer, to which she replied no. Mrs. Z had left a voicemail message for the framer, but he didn't return her call. She had previously arranged a meeting with the framer to discuss the painting. Judge Judy asked her why she didn't take the painting out of the car and put it in the Jeep. Mr. Van explained that he was a professional artist and had transported many art pieces in the past. He felt that the painting was secure in the trunk of the car and handling it more often would increase the chances of it being damaged. Judge Judy pointed out that Mr. Vanderzee's judgment was wrong, as the painting went missing from the trunk of the car. However, Mr. Berhane said that the wife had given him the key to the car and told him that all the belongings had been removed from the car. He explained that it was the usual process for detailing services, where the customer pulls the car to the back and a detailer would then come inside to tell the customer about the pricing and services. Judge Judy was not convinced by the Vanderzee's argument and found the whole thing ridiculous. She pointed out that neither of them were present when the painting was damaged and therefore they don't know what happened to it. The husband claimed that he trusts his wife, but Judge Judy told him that trust does not prove anything in a court of law. According to the wife, neither of them were present when the painting was damaged, and Judge Judy confirmed this with her. During the cleaning process, the detailer found a credit card, a phone charger, and several silver forks inside the car. Mr. Berhane and the detailer put the items in a small grocery bag and placed the bag in the trunk of the car. When Mrs. Vanderzee arrived to pick up her car, Mr. Berhane told her that the car was ready for inspection. She went out to inspect the car and found the grocery bag with her belongings in the trunk. Berhane acknowledged that he saw the detailer put the bag in the trunk but did not see what was inside. Mrs. Van's husband was in his car the entire time and never got out to inspect the car. After the inspection, she became upset with Mr. Berhane and accused him of stealing her items. This led to the dispute and their appearance in front of Judge Judy. Mr. Berhane stated that he had sent one of his employees, George, to investigate why the customer was having trouble closing the trunk. Berhane was the cashier at the time and couldn't leave his post to go outside. The judge asked him if he was aware of what happened outside, and Mr. Berhane replied that he could see the customer from where he was standing. George went out to investigate and showed the customer that the painting was getting caught in the trunk latch and causing difficulty in closing the trunk. The customer was upset and left without saying anything to Mr. Berhane. The next day, the customer called and George spoke to her. Mr. Berhane and his team apologized for the incident and offered to fix the Jeep for free to keep the customer happy. Mrs. Vanderzee stated that she spoke to someone the next day and that the person acknowledged the damage that occurred on the car wash's property. However, the husband stated that what George was saying was a complete fabrication. He further stated that he was present when the cars were dropped off and he and his wife explicitly told the associate not to go in the trunk. Judge Judy expressed her thoughts on the situation, stating that she finds it ridiculous that the painting was left in the trunk. Mr. Z, however, stated that he has moved pieces before without any damage occurring. The judge asked Mr. Van to subpoena the clipboard that the associate wrote on to get to the bottom of the matter. He claimed that he had never left the painting in the car while it was being detailed before, but Judge Judy was skeptical of this statement. She pressed him further, asking if he was telling her that he had taken the car to be detailed and the painting was never damaged. The husband corrected himself and said that he had never had a car detailed with the painting inside. Mrs. Van interjected and accused Mr. Van of lying. She claimed that the painting was damaged when the detailers threw a bag of items, including a phone charger, a credit card, and Jim's shoes, on top of the painting. However, Judge Judy was skeptical of this statement as well and pointed out that the husband claimed that the bag only contained a phone charger and a credit card. Judge Judy then questioned Mrs. Van about whether she was asked to remove everything from the car before it was detailed. She stated that the detailers had asked her to remove everything from the car, but if they found anything, they would put it in a bag. However, Judge Judy didn't believe this statement and accused Mrs. Vanderzee of not removing the credit card or the gym shoes. Mrs. Van explained that they were under the seat and she didn't see them. The wife then added that they had asked the detailers to stay out of the trunk, but Judge Judy asked to see proof of this request, and she claimed that the detailers kept the receipt. But Judge Judy reminded her that as a lawyer, she could subpoena their records if she needed to. Mr. Berhane, one of the detailers, interjected and claimed that they never said to stay out of the trunk. Mr. Van also backed up this statement and accused Mrs. Vanderzee of lying. In the end, Judge Judy ruled that the Vanderzees did not have a case against the detailers as they couldn't provide adequate proof of their claims.